This is what I like about researching for content. You learn something new, you learn something old, you learn something more, you learn something different, and more importantly, you add more value to real estate clients by providing more information that might only be available if you do your own research or you ask the right questions to the right people. So let me do the research and you just sit back, grab some popcorn, and relax. My name is George Ryan Termago, and today we are inside Cebu IT Park. Hello Real Estate, George here, and if this is your first time around here, please do me a favor and hit the subscribe button and the notification bell so you'll be informed when a new video comes up from this channel. So here is what we know. Foreigners can own a condominium unit so long as 60% are owned by Filipinos. And this is stipulated in Section 5 of Republic Act 4726 or the Condominium Act of the Philippines. And it says that where the common areas in the condominium project are held by the owners of separate units as co-owners thereof, no condominium unit therein shall be conveyed or transferred to person other than Filipino citizens or corporation at least 60% of the capital stock of which belong to Filipino citizen. But foreigners cannot own land here in the Philippines. That's the rule. Well, that is true, except that there are recognized exceptions on when foreigners can own land in the Philippines. So if you are a foreign citizen that is looking to purchase and own land here in the Philippines, or a real estate agent that has foreign clients, I'm going to show you 5 ways a foreigner can own and buy land here in the Philippines. Ready? The first one is through a corporation. This is a valid and legal loophole used by foreigners looking to own land here in the Philippines. This simply requires the establishment of a company to be registered in the Securities and Exchange Commission or SEC. Although they will not technically own the land, foreigners may indirectly purchase and own it through a corporation without violating the constitutional prohibition, so long as Filipinos must still have majority ownership, and that's at least 60% stake of the corporation. And that's per Section 7, Article 12 of the 1987 Constitution. Foreign investors may also consider entering into a long-term lease of private lands instead. Subject to certain conditions, a foreign investor may lease a private land for a period not exceeding 50 years. Renewable once for a period of not more than 25 years. The second way foreigners can own land here in the Philippines is through marriage to a Filipino. If a foreigner is married to a Filipino citizen, the foreigner is allowed to buy land, but because of the constitutional prohibition, however, the title to the land called the TCT or the Transfer Certificate of Title can only be registered to their Filipino spouse. The foreigner's name may be included in the contract or deed of sale, but it cannot be in the TCT or land title. And the Filipino spouse should also not renounce their Philippine citizenship even if they become citizens of their spouse's country of origin. But if the Filipino spouse have renounced it but want to reacquire it, he or she can do so by becoming a dual citizen under Republic Act 9225 or the Dual Citizen Law of 2003. Natural-born Filipinos who eventually lost their Philippine citizenship to another country because of naturalization may regain their Filipino citizenship after swearing allegiance to the Philippines. Now here is another exception. A foreigner can legally buy and own land if he or she was a natural-born Filipino. The Philippine Constitution defines a natural-born Filipino as a citizen of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. Specifically, the following people are classified as natural-born Filipinos: a citizen of the Philippines at the time of the adoption of the 1987 Constitution, born after January 17, 1973, whose fathers or mothers are citizens of the Philippines at the time of their birth. Born before January 17, 1973, may be born anywhere in the world to a Filipino father or to a Filipino mother, and that person elects Filipino citizenship upon reaching the age of majority, which is 18 years old. Naturalized under the Philippines Naturalization Law: a citizen of the Philippines who married a foreigner but have renounced their Filipino citizenship, and those who acquired dual citizenship. Those who acquire derivative or the origin or descent citizenship, like the unmarried child, legitimate or not, or adopted, below 18 years of age. Of those who reacquired Philippine citizenship upon effectivity of RA 9225 or the Citizen Retention and Reacquisition Act of 2003. And the fourth exception that foreigners can own land in the Philippines is through hereditary succession. Acquisition by hereditary succession simply means that a foreigner can acquire land if he or she is a legal heir of a Filipino who owned it and who died without a will, or what we call intestate succession. Articles 978 to 1014 of the Philippine Civil Code enumerate the order of hereditary or intestate succession as follows. The first one is legitimate children or descendants of the deceased. Second is legitimate parents or ascendant. The third order is the illegitimate children or descendants. The fourth order is the surviving spouse. And the fifth order is brothers and sisters. The sixth one is other collateral relatives within the fifth degree. And the last one is the state. And the last exception foreigners can own land here in the Philippines is through acquisition before the 1935 Constitution. This is straightforward. A foreign citizen who was able to purchase and own land prior to the enactment of the 1935 Philippine Constitution will retain his or her ownership rights on that property. And prior to the 1935 Constitution, there was no law prohibiting foreigners from owning lands in the Philippines. It was only in the 1935 Constitution that the reservation of land ownership to Filipino first made its appearance. And Section 5, Article 12 of the 1935 Constitution reads, "Save in cases of hereditary succession, no private agricultural land shall be transferred or assigned except to individuals, corporations, or associations qualified to acquire or hold lands in the public domains in the Philippines." And according to Section 1 of Article 12, only Filipino citizens or corporations, at least 60% of which is owned by Filipinos, are qualified to acquire and hold lands of the public domain. Even though the 1935 Constitution has been already replaced by the 1987 Philippine Constitution, the new Constitution continues to recognize the rights of a non-Filipino citizen to use and own the property, including land, as long as it was acquired by the foreign citizen before the 1935 Constitution. So there you have it. 5 exceptions for foreigners to own land here in the Philippines. Once again, this is George Ryan Sarmago, Unit Manager for Filipino Homes, and I hope you learned something. Thank you for watching. Stay safe, stay at home, and peace!